30 cases that came out this past year. Peter, do you want to start us out with Apps versus Universal Music Group?
Sure. Apps was a songwriter who had done a song that included the lyric, I need to know now. She had a CD. She ran into Jay-Z at a gym and gave him the CD, she says. And he said, well, send it to my office as well. So she did that. And then John Newman came out with the song that had the lyric, I need to know now. And so she sued for copyright infringement. The district court threw it out on summary judgment, which is kind of interesting because we're going to look at another case where it was dismissed at the pleading level, and one might wonder why this wasn't dismissed at the pleading level. But the Court of Appeals just affirmed in a per curiam opinion. The district court on the summary judgment motion got into it in more detail, of course. On access, the plaintiff's sole theory was that she had given it to Jay-Z and as well to someone else, both of whom had a relationship with Universal Music Group. Now, Universal Music Group is the largest music company in the US, if not the world. And so you'd have to really beat the bushes to try and find someone who doesn't have some relationship with Universal Music Group. Ninth Circuit law is also pretty clear that you have to establish access, you have to submit something to someone who actually was involved in the creation of the work, and Jay-Z had nothing to do with this. So that was pretty easy. As you probably all know, normally people don't confess to copying, so you prove it by a combination of triggering an inference of copying by a combination of access plus substantial similarity. And the judge also dealt with substantial similarity, the district judge, although arguably he could have stopped at the lack of access. And on substantial similarity, the point about lyrics was that the only similarity that the plaintiff alleged and argued in summary judgment was the copying of the phrase, I need to know now. And I don't know why I keep reading it because it's short enough I should have remembered it. But, and the district court judge relied on established Ninth Circuit law that you can't protect a short phrase, period. Which Aaron will talk about in the Swift versus Taylor reversal.
Just so you know, the outline says, I need to know how.
Oh, okay. Well, I didn't do the outline. But we'll say that. And then on music, because theoretically there could have been a similarity in music, the plaintiff just said they sound alike and didn't present any expert testimony. And normally in music cases, you need to have a musicologist. The rule isn't hard and fast, but that's basically what judges require. So it was an odd case in the sense that it was so weak. She wasn't pro se. She had no real proof of access and no proof of access that was consistent with Ninth Circuit authority. The lyric claim relied solely on this one short piece of lyric, and there was no musical similarities. But in any event, she appealed, and the Ninth Circuit affirmed. So Jay-Z doesn't have to worry about, and John Newman don't have to worry about that case anymore. The other case, if I should just...
Yeah. On the film side, we've got Alfred versus the Walt Disney Company, and go ahead and...
Yeah, that's an interesting case, in part because it is a 12b6 dismissal, and it's also a much more complicated case because the plaintiff had done a screenplay that was inspired by and based on the Disney ride Pirates of the Caribbean. And she sued Disney over all the Pirates of the Caribbean movies. And so what Judge Marshall did, to her credit on 12b6, after the defendants asked the judge to take judicial notice of the movies, was to actually compare the plaintiff's screenplay to the movies and granted a 12b6 motion. The kinds of similarities that the judge dealt with were things like, the judge applied the Shaw test, which is you look at whether there are objective similarities in the sequence of events of the plot, characters, dialogue, theme, setting, pace, mood, and I may be forgetting one, characters. And what the plaintiff argued was that in terms of similarity in plot, that both movies have skull-faced pirates, which actually really isn't a plot element, but the judge mentioned it and said, look, that's generic, that's not going to get you anywhere. On characters, it was kind of interesting because one of the similarities she found was that both featured a pirate who was jovial, friendly, nice at heart, and really liked rum. And, and it's hard to imagine a more generic pirate, I suppose, at least in a movie, other than someone evil like Blackbeard or something. There was another similarity that she claimed in one of the other characters, another pirate, but in her own, in the Pirates of the Caribbean, he's a pirate. He's got, he's missing an eye, he's got a parrot, he's, ragged and all that kind of stuff. And in her screenplay, this guy is described as a distinguished naval officer. So, on dialogue, there were just snippets of dialogue, and this is something that goes back to Litchfield, where someone just has a list of various similarities, they're taken out of context and all that. So the judge was able to just get rid of that one. And the setting, I thought, was kind of interesting because her claim of similarity in the setting was that both her screenplay and the Pirates of the Caribbean movies deal with pirates at sea.
Imagine that.
And the judge said, well, you based it on the ride Pirates of the Caribbean, which includes pirates at sea. So Judge Marshall granted the 12b6 dismissal. I don't know if the plaintiff has appealed, but again, the interesting thing to me about that is on the one hand, you have apps, which is on its face, no offense to counsel, it's just such a completely weak case, and it has to go through summary judgment, which means depositions were taken, answers were given, God knows, how much time they spent on all that. And then you have Alfred versus Walt Disney, where you're talking about comparing a screenplay to movies, and it's dismissed on 12b6. Now, I don't know if you're following it, but that's actually a big issue right now in the Ninth Circuit. There's a case, Ashton White, I think it is, where Judge Wardlaw, although she concurred in the dismissal in an unpublished decision, concurred in the dismissal of a screenplay case on 12b6 grounds, or agreed that the judge properly granted the dismissal. She voted to reverse on the grounds that the plaintiff should have been granted leave to amend. But Judge Wardlaw went on to talk about how terrible it is that cases are dismissed at the pleading level in cases involving literary works. And a couple of weeks ago, she was on the panel where Shape of Water was argued, which also is a 12b6 dismissal. And so I think what you're going to see is you've got Rentmeister, which was an affirmance of 12b6 involving photographs, where the Ninth Circuit said, look, if you've got the works in front of you, you can look at them, and there's clearly no way they can pass the extrinsic test. You can throw it out on a 12b6 dismissal. But then you've got a current panel that includes Judge Wardlaw that involves a screenplay, and we're all sort of like waiting to see, what's going to be the outcome of that. But that is, as I said, an
I was
important
just
issue.
going to say, historically, there's been, for many, many years, we've had 12b6 dismissals on film cases and TV and screenplays as opposed to music. And my theory has always been that judges feel much more comfortable comparing two written works because they deal with written words all the time. But when it comes to music, they're much less comfortable, and that's why there's been a tendency to go to experts in that case. It is really going to be unfortunate if they decide that you can't dismiss cases on 12b6 for both litigants, because they're both going to incur a lot of costs if they have to have experts.
Right.
And now under Romini, you can't recover your expert witness costs either. So I'm not sure whom that serves.
Yeah.
You're absolutely right. And that's been a point that I've been trying to make. And I argued a case, which I won't identify, where it was a music case, and I started explaining to the judge, or answering a judge's question about, and explaining why the musical similarity really wasn't a similarity, and she waved me off and said, I don't understand any of that. And then if you go back, there's a case from New York in the 40s, it's a landmark copyright case, I don't remember the name of it, but I'm sorry? Yes, Arnstein versus Reporter, where the dissent says, just read the music, that's all. And the problem is, a lot of people, in the old days, everyone grew up, and everyone's an exaggeration, but people grew up learning how to play instruments and read music.
Yes.
my mother was, she was first generation immigrant. She knew how to play a piano because that's what she did. And so she could read music. Nowadays, people rarely can. I was on a panel with probably twice as many people as are here, and we asked, how many people can read music? 7 people raised their hand. I mean, and so you've got situations where judges just, they just don't know. They just don't understand it. It's Greek to them. And one of the nice things about one of the cases that Pierre mentioned, the Gwen Stefani case, is that the judge, it was a summary judgment motion, it involved music, and it involved Judith Fennell on the other side, who claimed all these similarities. And the judge went through them one by one and said, no, you can't, that's not a similarity. This isn't a similarity, this isn't a similarity. But that is very rare. That is very rare. Most judges, when it comes to music, Gail's exactly right. They just throw their hands up and say, let the jury decide, we've got an expert. And you can get an expert on the music side to say just about anything. So
On everything, you can get an expert to say anything.
well, yeah.
Sticking to the films for a little while, Aaron, why don't you tell us about there's a couple Zootopia cases.
Sure, yeah. And I agree with the comments about the state of the law in terms of whether or not a judge can or should be able to decide substantial similarity cases on 12b-6 motion. Contrary to what Judge Wardlaw suggested in her Astor White concurrence, which was in the Empire case, she said, and she was technically correct because she said there are absolutely no Ninth Circuit published opinions in which we have affirmed the dismissal of a copyright case on substantial similarity grounds. Now, that being said, there are numerous unpublished Ninth Circuit cases that have done just that.